car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome to the Attorneys. I'm Art Franklin as we talk about navigating through workers' compensation. It's a topic you've probably heard before, but there is so much to cover that we're going to give you more information today. Also want to remind you that right now, attorneys are lining up so they can take your call at Hollis Wright. Is 1-844-LAW-TALK. You can call them, ask your question, and it is free and it is confidential, and we're ready to get into our topic on workers' compensation. Josh, like I said, we've talked about this before, but we've got Kevin Berry here who's going to really take us to another level.
Yeah, so Kevin is an expert in this area, and one of the things we asked for him to do is to focus the show a little bit on the money side of workers' comp, as we've done a lot of different shows in the past related to the medical side.
Yep.
There's a financial side, a compensation side that we're going to focus on tonight, because this is an issue that faces people that are sitting on their couch right now that are receiving workers' comp benefits. They think they're too low, they're not appropriate, they don't feel like it was discussed appropriately when they signed their settlement agreements. We're going to talk about all that today and some of the things that you can do. Kevin's an expert in the area, and first of all, thank you for being on. So happy to have you.
My pleasure.
Absolutely. Tell us just a little bit about your practice. I know you focus a lot on workers' comp, but tell us a little bit about your practice.
So I've been at it for 22 years. As you alluded, primarily workers' compensation. That's my wheelhouse. I do handle personal injury, business formations, wills, sort of your solo practitioner's spectrum of work, but comp is my wheelhouse. I'm past president of the comp section of the Birmingham Bar, the Alabama Association for Justice, and also the Alabama State Bar.
Well, and I know it's a significant issue in Alabama because we have a lot of folks that get injured on the job. We see a lot of it at our law firm too. What kind of just in general, unwrap this topic for us that we're talking about? I mean, obviously there's a medical side to this that's got to be managed, but we're talking more on the financial side, the compensation side tonight.
Right. So workers' compensation it's a discrete area of law, and it's not something that you see attorneys dabble in. I mean, you really have to do it or not do it. And once you have been at it for a few years, you really get the sense of the financial implications from your client's perspective. It's pretty onerous. There's supposedly a trade-off. The employer pays for the medical charges and handles any liability from the medical end of things, but if you want to resolve your case, you get an impairment rating, and we'll go into that, but you're in a position to resolve your case, and the money is just not anything like a comparable injury that happens, for instance, from a car wreck. So unfortunately, it's a rough circumstance for a lot of injured workers. Their income is continued if the doctor has them out of work. It's 2/3 of what we refer to as their average weekly wage, so they're not doing without. But once they're released by their physician, their authorized treating physician, those workers' comp checks stop.
Yeah.
And depending on how long it takes to get the claim resolved, and sometimes we've got to file a lawsuit, and litigation, as you know, can take a long time. So I've got a client in many circumstances that they're hurting financially.
Yeah, and talk about this, because I know there are people who have been through this process before that watch this show, but there are workers right now that have never been through the comp process before. Just kind of explain in general terms how comp works. We hear it as a no-fault system, but how it works on the financial side in general terms, kind of what your process is when you get an injured worker into your conference room and start talking to them about, hey, here's what you can expect moving forward. How do you have that conversation with someone like that?
Well, one of the first things that I do is I try to just be forthright and put forward the economic realities, and I make it clear that, look, none of us are going to be able to retire on your workers' comp case. Yeah. So I find that if you're frank with them and their expectations are not unrealistic, it makes for a better relationship during the course of representation. I need to know certain information. I need to know what their income is. The way a workers' comp case is ultimately resolved is it's a formulaic remedy. So you don't get to claim the same sort of damages that you may be able to claim in a car wreck, for instance. There's no pain and suffering. It's formulaic, and literally there's a formula. There's more than one formula, but it depends on the circumstances which one to use. But there's a formula that we use, and we plug in certain variables into that formula. And one of those, the main drivers of the value of a case in that formula are the person's wages and their impairment rating. And so we do some math on it. It's not that simple, but generally that's the Cliff's Note version of the formulaic resolution of a workers' comp case.
And I was wondering this, if
Hey, by the way, before you go there, can I say this? I'm going to use the word formulaic because I like it so much. I'm going to use it at home with my children. Here's the formulaic. Money in, money out. We need to make sure we have less money going out. All good stuff.
Absolutely.
Go ahead.
Dad will be happy if that happens. But I just want to know this, though. Can employees pursue a legal action if their workers' compensation doesn't cover all their financial needs?
Generally speaking, no. It's called the exclusivity provision of the Workers' Comp Act. And when you get hurt on the job, that's your sole remedy. Now, in some cases, you may have a liable third party that you can pursue. But as far as pursuing your employer outside of comp, the safest answer for me to say is no. There are some very, very narrow exceptions, co-employee actions and such, but the takeaway from the public should be that, hey, if I get hurt at work, I'm stuck with work comp.
Yeah, and what is, the law has not changed a lot over the last, since you and I have been practicing, not markedly. I mean, and not because folks like you have not tried to help injured workers get the law changed. But the legislature has been a little stubborn in this area, even though I do think they're pro-employee generally. But, you talk a little bit about impairment rating and income and the amount that they were working. Really, it is a formula. You're plugging that information in to a schedule most of the time in order to define what range someone would settle within. Is that fair?
Generally speaking, that's correct. You've got what's called the schedule, as you mentioned, and the schedule applies to certain body parts. The Workers' Comp Act here in Alabama was modeled after Minnesota's Workers' Comp Act, and that's a vestige of their statutes. So you have a schedule, and it lists certain body parts, and they're treated differently. Like I talked about the formula, you literally use a different formula to resolve a scheduled member injury case versus the opposite. The other cases are called body as a whole or whole person cases. So if it's a body part that's not listed in that schedule, it's a whole person case. An easy way to think about it is a scheduled member injury is an injury to an extremity.
Yeah.
So just below your shoulder down to the end of your fingertips, or just below your hip down to the end of your toes, and also your eyes and your ears, those are your scheduled member body parts. And the Workers' Comp Act treats those differently, and it's pretty rough.
I know, that's the good example and answer there. I know we're getting ready to go to break. When we come back, I do want to talk a little bit about how having a lawyer is so critically important to be able to negotiate resolutions that are positive for you, but also to be able to define an injury as a permanent injury as opposed to, a non-permanent injury. And sometimes that takes a very skilled, accomplished lawyer like Kevin to be able to handle those cases. So let's talk about that when we come back.
And your word is formulaic?
Formulaic, money in, money out. I like it. All
right, you're watching The Attorneys, and our topic on this show is workers' compensation. We've got more to get into on workers' compensation, but want to remind you that there's a QR code on your screen. If you scan that QR code, you can reach an attorney at Hollis, Wright, and you can ask a question. You can also find out any information you need, any question you want to answer from a live attorney who's watching, taking this call right now at 1-844-LAW-TALK. It's free, it's confidential, and he'll be there for you or she'll be there for you. So stay with us. We're talking workers' compensation and money when we come back.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best: help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
We love this state and its great people. People that are worth fighting for in their lowest moments. It's what drives our lawyers to do what we do. We're here right now to fight for you. At Hollis Wright, your result matters.
Welcome back to The Attorneys. We are talking workers' compensation and money. Also reminding you to follow Hollis Wright on all the social media platforms out there, whether it's X, Instagram, Facebook. We'd love to have you follow, share, and also subscribe to those social media platforms so you can keep up with what we're doing throughout the week, not just here on Sundays. But this show, we're talking workers' compensation. We've got much more to get into.
Yeah, so Kevin, when we were out to break, I wanted to talk a little bit in this segment about the importance of having a lawyer that's skilled like you for as many years as you've done this, to be able to help make sure that employees are properly classified with their injury. For example, some employees' injuries result in a permanent injury that has a completely different impact on the value of their case if it's not a permanent injury. So just kind of talk generally about how the categories work insofar as it relates to the money they can receive.
Sure. Well, the first bit of good news for the employee, the injured worker, is that the attorney's fee in workers' comp is limited by statute. So it's 15%. Typically, you're looking at significantly more than that in a what we call a personal injury case. Although an on-the-job injury is a personal injury, it's not referred that way in our industry parlance. So it's 15%, and you've got to get a lawyer. There are so many pitfalls and so many things that have to be addressed. And again, it's only 15% of the ultimate recovery, so trying to go it by yourself is not advisable. The types of injuries, or the way a person is categorized or classified by their physician once they reach MMI, and that's a really important term. Our industry's acronym heavy. Yeah. MMI stands for maximum medical improvement. Once the injured employee is placed at maximum medical improvement, meaning the doctor's done everything he can do, then he will typically assign, or she will typically assign, an impairment rating. So if that impairment rating burdens that injured worker to such an extent that they are fairly considered permanently and totally disabled, then that case gets different treatment. Again, we're talking about different formulas that we use to resolve the case. If it's a permanent partial impairment, then we use the formula and we put the impairment rating in there and we discuss the money, and that's basically how it's resolved.
You know, one of the things Kevin can tell us, but I know from experience too, is a lot of times workers are afraid to present a workers' comp claim because they're concerned they're going to get retaliated against or they're going to lose their job. And I mean, this job matters, right? It pays their mortgage, it pays for their family. And, you know, as Kevin can readily agree, there are components to the law that protect employees in those circumstances to make sure that they're not discriminated against. And sometimes those cases are more valuable than the underlying case.
Typically they are. Yeah, there's a cause of action called retaliatory discharge. There's a litany of cases, and they've all, I think back to the Alabama Aldridge versus Alabama Power case. But essentially, if a worker is terminated while they've got a workers' compensation claim, or they've simply notified their employer that they got hurt on the job, there's a cause of action called retaliatory discharge. The injured worker has to prove, and this is bolded and italicized, that they were fired solely in retaliation for filing a workers' comp claim. And that is something that we see. I've got a couple of them going on right now. And so, but the injured worker should not feel threatened or intimidated about bringing their workers' comp case. Typically, most cases are resolved without litigation.
Yeah.
And if I can expound on that just a bit, when you have a worker who's concerned or frightened about something, some of them may feel like this workers' compensation check is just too low. So what do they do in that regard?
Right. So again, using the word formulaic, there is a method by which we calculate what the injured workers pay while they're out of work is supposed to be. We start out by determining their average weekly wage. That's where it all begins. So the average weekly wage is the money that that person earned in the year prior up to the date they got hurt at work. There are some tweaks you make if they were out of work on vacation or whatnot. You don't count that week. That would take away from them. But we determine the amount of money. We divide it by 52 weeks, and that's their average weekly wage. 2/3 of that number is what we call their TTD rate, temporary total disability. That's workers' comp checks. So 2/3 of your average weekly wage is what you will get. And I get it a lot that they say, this doesn't seem right. My checks, I made more than this. This is too low. But a prudent attorney is going to obtain a wage statement. And the adjuster will go through that employer and get that wage statement. And I can confirm what the numbers are supposed to be.
Kevin, what about the circumstance where a doctor has returned someone to work, they're able to do a job, but maybe not the job that they originally had done given their injury, and the employer tells them, hey, look, we only can have you half time now because this job only allows for half time. How does an employee handle that, and how do you manage those things?
So that worker would be entitled to their normal pay for the hours that they do work. If they're working 4 hours and the other 4 hours the employer cannot accommodate them with work under their restrictions, then you revert back to 2/3 of their average weekly wage.
Okay. So there is a protection for them under those circumstances.
That's correct.
What are you seeing trends-wise on the money side, the compensation side of workers' comp? Are you seeing trends with insurance carriers, with employers, things that workers that you're having to protect the worker against more than you've seen in the past?
I don't know if I'd call it a trend, but very often I'll hear from my clients that they haven't received their mileage reimbursement check or their TTD check, their workers' comp check, was supposed to arrive today, but it didn't. So that's a common, and I don't think that those issues are intentional. These adjusters, they're loaded down with files to work, and the logistics simply sometimes they get delayed. A check doesn't get entered, or it doesn't get printed in time, or doesn't get direct deposited in time. And I tell my clients that, look, there's not a lot the lawyer can do about that.
Yeah.
What do? I file a lawsuit, I file a motion to compel. Well, they're going to have their check by then.
Yeah.
But it's just an ongoing, typical problem.
Well, and I know also, I mean, it's one of the reasons why you have a lawyer involved in these cases, because Kevin can send an email to the adjuster, Kevin can send an email to the defense lawyer, say, hey, look, I know this is an oversight. Let's make sure we get this accommodated immediately. And that probably is something that can be done by a lawyer that the individual may not know how to do to get it resolved quickly. I know we're getting ready to go to break. We'll unwrap more of this when we come back.
And want to remind you that you can still get a lawyer right now at Hollis, Wright. They're manning the phones. When we start the show, they start taking your calls live. They'll be with us throughout the show. So you have until the end of the show for an attorney at Hollis, Wright to answer your question. It's free, it's confidential. The number's easy too. It's 1-844-LAW-TALK. We're talking workers' compensation, and we'll be back in just a minute.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
Hollis Wright has been handling workplace injury cases for years. If you've been injured on the job, give us a call. Our attorneys are standing by right now to give you a free consultation. And remember, at Hollis Wright, your result matters.
We welcome you back to The Attorneys, and we are talking with Kevin Berry, and we're talking workers' compensation. And Kevin, I got a question I want to ask you. Here's a question that came in. It says, my neighbor was in an automobile accident and settled his case for a lot more money than I got in my workers' compensation case, even though we both had the same shoulder injury. Why did he get so much more?
Well, in a personal injury context, and again, an on-the-job injury is a personal injury, but in our industry, we refer to it as a personal injury case, a motor vehicle accident, a slip and fall, that sort of thing. You get to claim damages that you do not get to claim in workers' compensation. As I mentioned, workers' comp, the way the cases are resolved, it's a formulaic thing. So there's no component in that formula to insert pain and suffering. Mm-hmm. You literally do not get anything for pain and suffering. It's a pretty cold, hard mathematical assessment, and it spits out a number, and there you go. That doesn't mean you have to settle your case for what that number is. Mm-hmm. The attorney should maximize the value of the case, and sometimes that means filing suit.
And I guess also the trade-off is that the workers' comp statute, since its inception, has been a no-fault system where you do not have to prove that the employer is at fault for your injury and you're compensated, meaning that the value of that case is lower. On the civil side, in that car accident, we have to prove that someone caused the accident and the person that was injured didn't contribute to it, because if they contributed, they can't recover. So there are trade-offs for everything that we have in the law, including the difference between civil cases and comp. Hey, I know that there is a trend that I've heard of, and you talked to me a little bit about this, and that is that scheduled injury claims versus body as a whole or non-scheduled injury claims as to value and whether you can make more in one over the other. Is that kind of a trend that you have seen over the last couple of years?
Well, what you said is a fact. As far as it being a trend, I don't think I would characterize it that way. The trend in that respect is that there are some workers' comp practitioners who just cannot economically justify handling a scheduled member injury case because those are typically lower valued cases. And again, the attorney's fee is limited by statute to 15%. Mm-hmm. So the practitioner has to be prudent in deciding which cases to pursue. If you have a serious injury and it's to a scheduled member body part, again, generally your extremities. One of the really important distinctions between a scheduled member injury and a body as a whole injury, or an injury that is not listed in the schedule of body parts. If there are permanent restrictions resulting from that injury and the employer cannot accommodate the worker with legitimate work under those restrictions, if it's a non-scheduled body part, a back injury, for instance, we take that formula and whatever that physical impairment rating number is assigned by the doctor, we throw it out and we substitute it with a vocational impairment rating. Those are always higher value cases. Okay. The problem with scheduled memory injury cases is you don't get to claim vocational injuries, vocational damage with a scheduled memory injury case, even if the employer cannot accommodate your permanent restrictions. That's just a facet of the law, and the court cannot entertain any evidence of vocational disability.
This is why you want to have an experienced lawyer like Kevin to be able to manage and handle these cases.
Yeah. Something else I was wondering is the cases involving mental health. Are those covered as well?
They can be, but you need an associated physical injury in that respect.
Like a head injury or something?
Yeah, and it doesn't necessarily have to be a permanent serious injury. If you have someone who was taken to the ER and they were diagnosed with a concussion or what have you, and they had resulted, and I had one of these exact cases, they had some PTSD or mental issues as a result of that attack or whatever it may be, yes, you can claim those damages.
Or something that people may not understand that I think Kevin can do a quick job explaining as we're wrapping up here is that if there is a third party that was at fault for causing the injury, or there is what's called a co-employee component to your case where you can bring suit against a co-employee or a third party, the workers' comp carrier paid money for your case. They're going to want that money back or a portion of that money back by way of subrogation. A lot of people don't understand that.
Right, so subrogation is an equitable concept. If the employer, their workers' comp insurance carrier, pays money for the medical treatment and there is a liable third party outside of the employment relationship and the injured worker can pursue a case against this third party, if they get a recovery under the law, the monies that were spent by the insurance carrier, workers' comp carrier, they're entitled to be paid back. Now there's a remedy, there's a specific method, again formula, by which we can reduce that amount.
Yeah.
I've got a case right now where uninsured motorist coverage is in play, and just a quirk of the law currently at least, there's no subrogation allowed.
Yeah, in an uninsured motorist.
That's right. That's right.
Hey, great job. Really appreciate you coming on.
My
You were
pleasure.
very helpful to the viewing audience.
Yep, indeed, Kevin. A lot of good information there. But the information does not have to stop. Hollis Wright's always going to give you that information, and we can do that by way of the social media platforms on X, on Instagram, on Facebook. Follow us, subscribe to those platforms, and you can continue to get information from Hollis Wright. But also make sure you join us next week for another episode of The Attorneys. I'm Art Franklin. So long. We'll see you back here then.
Thanks for watching The Attorneys, sponsored by Hollis Wright.